I'm Stan Miller, and we'll be unlocking the secrets of legacy planning because powerful protection is your greatest asset. A couple key things have to be in a will. Number one, you've got to designate who you want to have in charge of managing the disposition of your assets when you die. The other thing you have to answer in a will is who gets my property when I die, and how do they get it? Do I leave it to them outright, or do I leave it with some kind of protection? Also, if I have minor children, a will's the place I would designate who I want to be the parent of my child if I'm not able to be that parent because I'm gone. So there are two key reasons why you need to have a lawyer help you make your will. Number one, you need to make sure that the will is properly executed so there aren't legal issues around the formalities of how it's signed. The other reason is that a lawyer knows a full range of planning options that are available that most lay people don't know. There are some really powerful tools out there that you miss because you don't know about them. There really are two ways you can plan for who gets your property when you die. One is with a will, and the other is with a living trust. You can really do the same thing in each of them. You can specify who gets what in each of those documents. The difference is, with a will plan, you have to go through probate. That means you have to go through the expense, the delay of probate, the fact that all of your business affairs are open to public inspection. With a trust, you can designate who gets your property when you die, but you can avoid that whole probate process. There is a massive amount of peace of mind that you have by knowing that you have clearly specified who's going to get your property when you die. Most of the people I work with do not want to leave a mess. They don't want to have they don't want to have the family in conflict. What we do as estate planners, using wills sometimes, using living trusts sometimes, is we make those instructions clear so there's no argument about it. So a living trust is, I want to say, a fairly recent innovation. For the last few hundred years, wills were the key legal document that you signed to specify who gets your property when you die. The problem is that with a will, everything goes through the probate process, and almost everybody would like to avoid that. And the way we avoid that is by creating a living trust and incorporating in that living trust all the same instructions that you would put in a will, and then making sure that your assets are properly funded in the trust. And because those assets are in a trust, they completely bypass that court-supervised probate process. The probate process is expensive and time-consuming and complicated. There's a ton of paperwork that goes with it. An attorney can step into that process and really get in front of the conflict that will emerge between family members if they're handling this process unsupervised. Probate can be avoided every single time, and the best way to avoid probate is to create a revocable living trust and take the assets that you own in your name, transfer them into that revocable living trust so that when you die, you don't own them, the trust owns them. And the trust becomes a substitute for a will, and those instructions are carried out by a trustee without delay and without the need to go through that court-supervised process. Estate planning is that process that people go through to make certain the assets they have are protected in the event they become incapacitated, and to make certain those assets are left to the people they care about in the right way when they die. It's that simple. So the estate planning process for attorneys, and I can tell you, we've done this for 30 years at Pinnacle Legacy Law. We sit down with a client, we hear their story, we meet them, we learn about them, we learn about their family, we learn about their assets, and then we learn about their specific objectives. And once we have clarity around the outcomes they're looking for, then we can use all the knowledge that we have and the tools that are available to develop a plan that accomplishes all of those objectives, and then we put that into legal documents, and in a week or two, we have the clients come back and we have a meeting and we sign those documents and the plan is done. Asset protection is a huge issue for a lot of people. We don't want to work our entire life and and then have everything that we worked and saved lost because some plaintiff's lawyer sues us and they take it all away from us. We play a really important role in that because there are some very powerful planning tools, different kinds of trust, limited liability companies that can be created so that we can build an insulation around those assets to prevent them from being taken away from us if we get sued. There's a lot of misunderstanding about powers of attorney, but it's a legal document that is only effective while you're living. In a power of attorney, we have the power to name the persons that have the right to manage our property for us if we're incapacitated, and we can name the persons that can make medical decisions for us if we're not able to make them for ourselves. All of that is done in a power of attorney. There are a lot of issues that come up when we get older, particularly around health care and how we pay for it. Long-term care, nursing home care, assisted living care. So what we do in elder law planning is we get in front of that and we identify that risk before it has arrived for us. And there are really amazing planning tools that are available that can be implemented so that whenever the time comes that we do have to go to a nursing home, we've positioned this client so they qualify for the Medicaid benefits so that the client does not end up at risk of dying broke in the nursing home and having to spend everything and leaving nothing to heirs. At Pinnacle Legacy Law, leave your legacy with powerful protection.